5 seconds. Start. On November 29, 1978, the Gurdaspur Central Cooperative Bank Limited, Gurdaspur hereinafter referred to as the bank, had advertised certain posts of clerks and peons full stop. Since the process for selection and recruitment had to take some time, the bank appointed some persons on purely ad hoc basis full stop. These appointments were for the period of 89 days full stop. Since the selection could not be completed, the appointments were periodically extended full stop. It is agreed between the parties that the appointments were made during December 1979 full stop. In August-September 1979, the bank terminated the services all the persons who had been appointed on ad hoc basis full stop. Thereafter, it had appointed persons who had been regularly selected full stop. Aggrieved by the termination, 17 persons raised an industrial dispute full stop. The appropriate authority made separate references to the labor code full stop. These references were consolidated and decided by the labor code while its award dated February 7, 1986 full stop. Agreed to the code, the bank filed CWP numbers 1196 of 1986 and 9053 of 1987 full stop. The workmen, on the other hand, filed CWP number 6866 of 1980, claim the consequential benefits flowing from the award of the labor code full stop. The two petitions filed by the bank having been allowed, the bank has filed these three appeals full stop. Learned counsel for the appellant bank has contended that the respondent workman had not completed service for 240 days full stop. Thus, they were not entitled to the protection of section 25F full stop. Still further, it has been submitted that in the circumstances of the case, it could not be said that the bank was guilty of adopting an unfair labor practice full stop. On behalf of the respondent workman, it has been submitted by the Learning Council that the registrar had issued instructions that none of the workmen should be allowed to complete a service of 240 days full stop. This was symbolic of the real intention of the appellant bank full stop. The short question that arises for consideration is, did the bank act unfairly in terminating the services of the respondent workmen before they had completed 240 days of service? Is it the admitted position and has not been disputed by the counsel for the respondent workman that the post had been advertised by the bank on November 29, 1978 full stop. It has also not been disputed that after the advertisement, the bank had actually appointed 53 persons in November 1979 full stop. Still further, the bank had specifically pleaded before the Labour Code in Para 1 of its preliminary objections full stop. In view of the admitted position that the post had been actually advertised and the facts that the respondent workmen had been appointed on the post of clerks and peons on purely ad hoc basis for 89 days, it can be safely inferred that the bank had intended to make a temporary arrangement full stop. It also cannot be disputed that an employer has the right to make an ad hoc arrangement pending a proper selection full stop. In such a situation, if the employer terminates the services of the persons who had been appointed on purely ad hoc basis, it cannot be accused of having acted unfairly full stop.